We'll just have a discussion on what we had. We'll just have a sort of brainstorming on the issues which we discussed in the last two lectures. This would be my last lecture. Uh, so anybody of you can somebody tell me what was understood, okay, as a way of comprehension in the last lecture. What is the topic of the last lecture? We had two lectures, right? Yes or no?
Yes, sir.
Okay. So what were the topics? What was the topic of the first lecture and what was the topic of the second lecture? What are we discussing? Anybody?
In the last lecture, we discussed about constitution, like what is actually written in the constitution book and how it should be followed, what is not.
Okay. Anybody else? Specifically, what did we discuss? Like, what section of the Constitution did we discuss?
We discussed some articles. Uh, it's like women welfare, the education.
Hmm. So that's correct. But what category of articles we were talking about? Like, if you want to broadly group those articles, okay, so we grouped them under some heading, no? And that was what was being discussed. Some part of the Constitution we talked about, and specifically about we use some certain terms there, okay, to broadly categorize those articles. So what was that category? All these rights which we talked about, okay, were they enforceable? So can we approach the court and seek a remedy from the court for not being conferred the particular rights, the rights which we discussed in the last lecture? Yes or no? You got my question or no? The question is, we talked about certain rights. Okay, we talked about some very interesting rights which the Constitution conferred us, and those rights, if they are violated, can we approach the court, the rights which we discussed in the last lecture? Can we seek remedy from the court for their violation? For example, if education is a right, okay, uh, and if somebody said that in 1950 somebody approached the Supreme Court and said that, look, the government is to provide free and compulsory education to all the children under the age of 14 years, okay, and then there were no schools, right? The government didn't have established the schooling network then in 1950, and if some parent, he was to sue the government for not giving them the free education, free and compulsory education. So was it possible within the framework of the rights which we discussed in the last lecture? That is my question. Is the question clear or not? Am I clear on the question? क्वेश्चन समजला आहे का मी काय विचारलं ते?
Yes, sir.
त्याचं उत्तर काय आहे, हो की नाही?
Yes, sir.
अजून कोण बोलतंय का? दुसरं कोणी?
We can approach the court.
Actually, what we said in the last lecture was that we cannot approach the court. Okay, and that was because what we discussed in the last lecture was the directive principles and not the fundamental rights. Getting it? What we discussed was the part fourth of the Constitution, which was titled as Directive Principles of State Policy. Okay, and whatever rights which we discussed there, and the articles which we discussed there, they gave us a broader framework of what is to be done by the future governments. Okay, and it talked of many good things which we discussed in the last lecture, but they were simply directions. Okay, they were not the rights of the citizens. Uh, uh, they talked about the philosophy and the direction which the policymakers should take in order to make this country a better country. Okay, but as I emphasized in the last lecture, they were not legally enforceable rights. They were not legally enforceable rights. So the rights which come under the directive principles, as they were put into, they were the guidelines for the policymakers to make future laws which are legally enforceable, but per se, those rights were not legally enforceable. So that was the distinguishing feature of the articles which we talked about in the last lecture, which are included in the part fourth of the Constitution. And these articles from 36 to 51, they are uh, extremely nicely worded articles. However, they are not legally enforceable. Okay. What we are going to talk today is a different thing. So, what is written here now on the slide? What are we to talk about today? What is written here on the slide?
Fundamental rights.
Okay, fundamental rights. So, what one understands from this term fundamental? This is a very interesting kind of legislation which has been adopted by India, the fundamental rights. Okay, and I'm going to talk about fundamental rights with perspective from the perspective of democracy. Okay, so what are fundamental rights? Fundamental rights, as they are the part of our constitution, they are included in the part 3 of the constitution. I said that part 4th of the constitution, they include the directive principles, and part 3 of the constitution, they include the fundamental rights. Now, directive principles, which form the article 36 to 51, as I said, they are not legally enforceable. One cannot approach the Supreme Court, okay, for their violation. Whereas the articles 12 to 35, okay, articles 12 to 35, which form the part 3 of the Constitution, they are fundamental in the sense that they are guaranteed. Okay, these rights are guaranteed to the citizens of the India. Okay, and few of them are also guaranteed to non-citizens, but most of the rights are for the citizens of the India. And in case of violations of those rights, okay, if these fundamental rights are violated, one can approach the Supreme Court. Okay, the Supreme Court of India can be directly approached and under Article 32 of the Constitution. Okay, so this is the most important difference between the fundamental rights and the rights which are under the directive principles of state policy. Is this understood? Am I clear on this now? Yeah.
Yes, sir. Yes, sir.
Okay. So how I want somebody else to answer this question. So how are the fundamental rights which are in the part 3 of the Constitution different from the directive principles which we discussed in the last lecture, that is part 4th of the Constitution? Somebody else should answer this, please. या हॅलो आत्ताच सांगितलं ना, तेच रिपीट करायचं आहे.
Sir, because they're enforceable.
नाही तू कोण बोलताय है
Harshada.
हर्षदा सोडून बाकी कोणी बोलताय का अजून कोणी उत्तर दिले का हर्षदा सोडून मला हर्षदाचाच आवाज येतोय म्हणजे एकच आवाज येतोय that is why I am worried okay that whether the others are equally participative or they are simply logged in technically. I just want to make sure. So that is the reason why I'm asking this question as to what is the difference between the fundamental rights and the directive principles. हर्षदा सोडून कोणी उत्तर दिलं तरी चालेल सर तुम्ही नाव घेऊन विचारा शीतल सर
सर
मला कारण दिसत नाही कोणी मुलांचं नाव दिसत नाही
ओके मुग्धा
ऑल राईट
मुग्धा बोलू शकतेस
Yes, sir.
सांग
The court law or non-justiciable, the directive principle.
मराठीत सांगितलं तरी हरकत नाही काय
Means the fundamental rights are justiciable, which are enforced.
So we can approach the court if our rights are violated. Okay. All right. So let us start with the discussion. I hope that all of you are joined. So to begin with, we would be discussing the Constitution of India and the fundamental rights, and this discussion would be in the framework within the framework of Indian democracy. Okay. Fundamental rights are the rights which are guaranteed under Part 3 of the Constitution of India, and they comprise of Articles 12 to 35. Okay, so there are some 6 fundamental rights which are recognized by the Indian Constitution, and they can be so these articles can be grouped into 6 categories. Okay, for example, we can club the articles 14 to 18 under what is known as right to equality. We can club the articles 19 to 22 under what is known as the right to freedom, and we can club some articles under right against exploitation. Then there are certain rights and some articles like, for example, 25 to 28, which could be clubbed under a right to freedom of religion. And then there are some educational rights, and finally there is a right to constitutional remedies. So these are the fundamental rights. So there are 6 broader categories of fundamental rights. Okay, there was one fundamental right which has now been removed as a fundamental right, and it is no longer a fundamental right, which is called as a right to property. Okay, so right to property is no longer the fundamental right; it is now a legal right. Okay, and as I said, in case of fundamental right being violated, the Supreme Court of India can be directly petitioned under Article 32. Okay, so Article 32 is also an article which is a part of fundamental right, where one can go to the court straight away and seek constitutional remedy as to if the fundamental rights are violated. Okay, so these fundamental rights, why they were included in the Constitution of India and how it helps to strengthen the democracy, that is what we are going to discuss. So if you look at a bit of history as to whether the fundamental rights are included in the other constitutions and what exactly they guarantee. So we need to look at the 3 developed countries. One is the England, other is the United States of America, and third is the France. Okay, so if you look at the Constitution of England, it is unwritten. Okay, so there is no code of fundamental rights as in the constitution because it is unwritten. However, in England, there is something called as bills of rights. Okay, so these bills of rights, they do give the rights, the basic rights of an individual. See, fundamental rights are the rights to the individual. Now, why are the rights important to the individual? It is because the democracy, when we define democracy, we say that democracy is basically what matters is the opinion of an individual and not opinion of a community. So when you are saying a fundamental right, so we are basically talking about strengthening the liberty and rights of an individual person, not a group. Okay, so that is the most important factor, which has, or that is the most important philosophy behind the fundamental right. Okay, so as I said, England had this bills of rights, though they do not have the written constitution. America also had this United States Bill of Rights, and France had the Declaration of the Rights of Man. Okay, so these three, they hugely, you know that the constitution writers, they were the legal experts. They also studied the documents, the constitutions of the progressive countries, and whatever they thought was important for the Indian scenario, they adapted those. Okay, so this idea of fundamental rights also comes from studying the different constitutions of the people who have adopted democracy. Okay, so as I said, they have the origins in many sources, including the England's Bills of Rights, the United States Bills of Rights, and the France's Declaration of the Rights of Men. Okay, so this, as I said, this also has a very important legacy in the freedom struggle. As I said, that the constitution should not be simply seen as a document. It should be seen in the context of the freedom struggle. So you know that in 1919, there was something called as the Rowlatt Act, and you know that this was also called as a Black Act by Mahatma Gandhi. Okay, this was a Black Act by Mahatma Gandhi because it gave extensive powers to the British government and the police and allowed indefinite arrest and detention of individuals. Okay, people would be arrested, detained, there would be warrant and searches and seizures, and people were not allowed to gather in public places. So there were restrictions of public gatherings. You must be aware of the infamous episode wherein of Jallianwala Bagh. Okay, we have all studied this black chapter of Indian history, that is of Jallianwala Bagh. And what happened there, you all are aware. What happened there was General Dyer ordered firing on the non-violent people, the people who had gathered non-violently at Jallianwala Bagh, and there was a public gathering. Okay, so because that was in violation with the Rowlatt Act, that is, there was a violation in the sense that people were not allowed to gather in a group. Okay, so he could fire, the police, the General Dyer could fire, and that led to the killing of innocents, right? So this was also in the mind of our constitution writers, that there has to be, if the democracy has to survive, then there has to be a reasonable opportunity for the people to gather in public places non-violently and to protest. Okay, we are aware of so many farmers who have gathered at Delhi, near the borders of Delhi, and they are, as of today, they are doing a non-violent protest against the government, against some farm laws. Okay, so we are not going into the issues of farm laws, as I said, but they have the right, okay, to gather peacefully and make a stand, okay, put forth their views to the government of the day. So this was in the mind of the people when the fundamental rights were written. Okay, so essentially one has to look into the fundamental rights as rights of the individual against the right of the state. Okay, state means the government. So who is more powerful? What are the limitations of the power of the government vis-a-vis individual liberty, and what are the rights an individual citizen has, so that he or she is not uh, exploited by the government as also by the other groups. So this is important. Okay, so fundamental rights essentially would enhance the individual liberty. Obviously, they do have certain clauses. There are clauses included where we don't have absolute fundamental rights in that sense. Okay, so let us discuss some articles which I feel are important for us to understand in the context of Indian democracy. As I said, the fundamental rights were included in the constitution because they were considered essential for the development of the personality of every individual. Okay, so the perspective now here is a individual and not the society per se. The perspective is of a human dignity and not the general societal dignity, right? So this is to be clearly understood, that the fundamental rights were included in the constitution because they were considered essential for the development of personality of every individual. And what they considered was, the constitution writers, the writers of the people who wrote the constitution, they regarded that democracy has no meaning if the civil liberties, like the freedom to express oneself, that is the freedom of speech, the freedom of expression, and also the freedom of religion, were not recognized and protected by the state. So when I'm using the term state, clearly understand that we are talking about in the layman's language, the government. Okay, in the layman's language, the government. So this was understood by the writers of the constitution, and hence they were included in what is known as the fundamental rights. Now, as I said, we can categorize the fundamental rights. So this articles from 14 to 18, they can be categorized in right to equality. So what does this right to equality say? So right to equality, article 14, it guarantees the equality before law. Okay, so anybody, any citizen of this country is equal before law. So it is not that different people would have different laws. If you are a different caste, you are not to have a different law. If you are a rich person, you are not to have a different law. Okay, so each one is guaranteed equality before law as well as equal protection of the law if and to the people living within the territory of India. So this is an important right. You must be aware that even if a person does not have the economic means, okay, to represent his case before the law, okay, then somebody else can approach the court on behalf of this. Means let us say there are some poor people, and let us say that there are some certain rights of those poor people are infringed upon according to some educated lot. So those educated lot can put their way behind that poor people, and they can say that we are approaching the court because their liberty is at stake. Okay, so it's not that only the person who are rich, okay, or who are well off, they can be considered equal. So everybody is considered equal before the law. Article 15 clearly says that we are a secular country. How does it say? Article 15 clearly says that we are a secular country because it prohibits discrimination, okay, differences on the grounds of religion, on the grounds of race, on the grounds of caste, on the grounds of whether one is a male or female, and whether you are born in Uttar Pradesh or Maharashtra, that doesn't make any difference. So Article 15 would prohibit discrimination on the grounds of religion, race, caste, sex, place of birth, or any of them. Now this is an important article because we don't have dual citizenship like in United States. So in United States of America, people have two different set of rights. For example, if you are born in a particular state of Minnesota, for example, so they would have a different rights. Means maybe the people who are local there would have different rights and more rights in terms of let us say employment or like this. Okay, uh, and the people from outside would have less rights. Okay, so they might have certain special rights because they are having a dual citizenship and dual rights. Here we don't have this kind of thing. So here we cannot be discriminated on the basis of place of birth. Okay, uh, and same is said about Article 16. As I said, there is a guarantee that everybody has a right to have equal opportunity in matters of public employment. Okay, and the state cannot discriminate against anyone on the basis of religion, race, caste, sex, descent, place of birth, place of residence, or any of them. Okay, so a Bengali person can come over here and he can seek public employment over here. You can go and seek employment in Madras, right, Chennai. So this is guaranteed. So there is a guarantee of equality of opportunity, right? Now this has this I said that equality is absolutely essential if you want to talk about the development of democratic state, because democracy promised us that each individual would be equal before the law, each individual would have equal rights, and he or she would not be discriminated. So that was a promise which the freedom fighters made, and hence the right to equality does help in fulfilling this promise. Okay, so this is very interesting sort of articles which we have in the constitution. Now we did had we were having some talk of reservation, and there was a question asked as to uh, whether reservations, how do we look at reservations, or also a term called as affirmative action is used in place of reservations. So you know that in India, mm, a particular category of people like scheduled castes and scheduled tribes. So the castes which are included in the schedule of the constitution, which are known as scheduled castes, and the tribes which are included in the constitution, which are known as scheduled tribes, they were given some special provisions. Okay, and that one might say that that is in a way a violation of right to equality. Okay, because your Article 15, for example, would say that there should be no discrimination on the grounds of caste, okay, or race, or religion, or whatever. Now, how do we look at it? So the policymakers, the constitution writers, they clearly understood that this article, uh, the right to equality, this articles from 14 to 15, could be misused by the people who are well entrenched into the power structure, and they might challenge any special provisions which the state, the government of the day would make for the upliftment of the people who are thought to be backward. So they were aware that the people would challenge this kind of reservations or affirmative action, and under the under the garb of fundamental rights. Okay, so that is the reason why this has been specifically included in the constitution. This sentence that the state is not precluded from making special provisions for women and children or any socially and educationally backward classes of citizens, including the scheduled castes and scheduled tribes. Okay, so this is clearly written in the constitution that irrespective of, see, all these fundamental rights, as I said, they are not absolute rights. So one cannot go to the court and say that, okay, look, the government is giving some reservations to the people on the basis of caste, and so I feel that my liberty is at stake, my equality of opportunities at stake, and this kind of stuff. This cannot happen. We cannot challenge that because affirmative action is allowed in the constitution. That is because it was realized and it was well known that there are set of people who, by the virtue of being born to a particular caste, or a particular tribe would not have an equal opportunity, and they do not have an equal representation in the public services, okay, especially the bureaucracy. They don't have adequate representation in the public services, and they don't have adequate representation if you look at the data of the educated lot, and if you categorize it on the basis of caste, okay, or tribes, you'd find that certain sections of the people, they can be called as the backward caste or backward community. Or if you look at the data of the people employed in public service, then one would find that this is also the case. So this data was available, obviously, to the policymakers, the constitution writers, and hence it was thought that the spatial provision has to be guaranteed for the people who are socially and educationally backward. For women, because women, you know that when we have had freedom, then most of the women were illiterate. Okay, they were confined to their homes. Okay, and they were not allowed much freedom in terms of employment also. Okay, and opportunity. So this was considered essential. So that is what is written as a clause to the fundamental rights. So that the fundamental, under the garb of fundamental rights, no one challenges this affirmative action. This for Article 17 is specifically written, and this has the context of Indian caste system, okay, and the practices of untouchability. So we all know that India is a caste structure. India is a system. India is not India in that sense. India is actually a group of castes, and each caste has a individual the distinguishing feature of a caste is that there is by the law, okay, or unwritten law, people cannot marry outside the caste. Okay, that is a law of the community. It is not the law of the government of India. Okay, so people cannot marry outside their caste. That is a distinguishing feature of the caste system. How do you know that whether there is a caste, whether caste system exists even today or not? So caste system exists today because people, it is not a practice. The intercaste marriages are not that common. Okay, though there are few cases of intercaste marriages, but you would find that the distinguishing feature of Indian society is that people marry within their caste. Even if you are a computer engineer or you are an architect, you would always find a bride. Okay, and a boy would find a girl who is an architect. Okay, but of the same caste. If you are a doctor, okay, you would find a match. Okay, who is a doctor, who has a medical professional skills, but who also belongs to his caste. Okay, so this is generally the way the matchmaking happens. Or even if there is an arranged marriages, okay, there also generally the family background, the educational background, they are looked into. They are this secular kind of features are looked into, that whether the girl is educated, whether he or she comes from the boy or girl comes from a good family or a similar family, I would say. These parameters are looked into, but the most important parameter which is looked into is the caste of that individual. Okay, this is one feature of the caste system. The second thing is, so this remains intact even today. This is not abolished. What has been abolished today is the practice of untouchability. Okay, and that is because the fundamental rights didn't abolish the caste system. What it abolished was the practice of untouchability in any form. So that is clearly mentioned in Article 17, and it was made a punishable offense. Okay, the offense was made punishable by law. If somebody reports that a Dalit is not allowed to touch a particular place, okay, because he or she is untouchable, so one can complain and one can say that this is not at all allowed, because this leads to inequality in terms of social inequality. there were certain more proactive resolutions like Protection of Civil Rights Act 1955, which also guaranteed that social equality remains a issue. Okay, so in the fundamental rights, this right, how is it different from the other rights? So this right is actually the right against an individual. In that sense, means if an individual violates this right of the other individual, then he can be punished by the law. Means I am an individual, I would say that I have the right to practice untouchability. Okay, I am an individual, right? So I am me, right? And the government should not intervene whether I practice untouchability or not. It is my personal issue. Government would say no. Okay, we won't allow this practice of untouchability even if it fringes upon your personal right, because personal the liberty is defined in a more broader sense. Okay, according to me. So to give liberty to the people who are backward, to give liberty to the people who are so-called untouchables, would be considered enlarging the scope of liberty to all. Okay, that has to be understood in that fashion, that it would enlarge the scope of liberty. So in that sense, fundamental rights would strengthen the liberty and democracy. Okay. This Article 18 is very interesting. You know that earlier, prior to independence, people had this sort of titles like Rai Bahadur Sahab, Rajkumari Meena Kumari, okay, Rajkumari Meena Devi. This sort of titles were given, or even the Britishers, they had this sort of titles given to the people. Sir Rabindranath Tagore. Okay, so this Sir or is a title. Okay, what we call it as a Sir afterwards is used in academics. That is a different sense. It is not a title. Okay, you can call me Mahesh Sir. So that is not the title given by the government to me. Okay, it's just a way of addressing the people in academics. But earlier, the Britishers, they conferred these titles of nobility like Sir, or the princes, they used to be given this sort of titles. There were princely states even in prior to independence. Okay, so Rai Bahadur, Rajkumari, this were aristocratic titles, and because we have abolished the Rajashahi, the aristocracy, the Nawab Shahi, we have abolished the Rajashahi and Nawab Shahi. So these titles are also out of place now. So to call somebody Nawab, to call somebody Rai Bahadur, to call somebody Rajkumari, this was considered to be discriminatory. Okay, this was considered to be the one which would bring in social inequality. So Article 18 clearly prohibits the government, the state, from conferring any titles. Of course, some exceptions were made, like those from academic institutions are given the title of doctor, okay, or delete, okay, or military. You know that there are certain titles the military confers. Okay, so they were considered to be in conformity with the fundamental rights. So Article 18 is also a negatively worded right, because it is not talking about what the individual has, but it talks about what the state should not do, okay, in distinguishing the people of the country. So that way it is framed. So Article 18 is about social equality. Article 19 talks about the freedoms. As I said that these freedoms had a legacy even in the freedom struggle, because especially I mentioned about the Overt Act, the Black Act, which led to the Jallianwala Bagh massacre. So this article, in a way, guarantees 6 freedoms in the nature of civil rights, and these are the freedoms available only to the citizens of India. Okay, so what are those freedoms? So the freedom of speech and expression. These are very important freedoms. Like you can speak, you can put forth your views. There are some reasonable restrictions. The freedom of expression is also the freedom, very vital freedom, especially in the context of free media. Okay, so one can, an editor can write his opinion about the government of the day. He might feel that this government is not responsible enough. he can criticize the government, okay, in his newspapers columns or in the print or even in the electronic media. One can write the article against the government, or anybody, okay, obviously with the reasonable sense of um, decency, okay. So this is given as a freedom of speech and expression. Then one can assemble without arms. As I said, that actually people have assembled without arms in the protest in Jallianwala Bagh, but that was not allowed by the Britishers. But in free India, we do have that right to assemble without arms. Okay, so the farmers which are agitating today near the borders of Delhi, okay, they are assembling. They have the right to assemble without arms. Okay, government can put in some restrictions that okay, they cannot go to a particular route because that would create some disorder and all that. And police permission also needs to be sought when you do such sort of assembly. But yes, we have that right to assemble and also form associations. We can form groups, like somebody would say that I form a club of no smoking club. Okay, the people who would not smoke or tobacco free. I form an association of tobacco free people. Okay, that is just to promote that people do not fall into the vices of tobacco. Okay, so this sort of association or is allowed in this six freedoms which are there. Then we can move from place to place. As I said, in United States, for example, you have to have a separate citizenship of a particular state. Okay, here we don't call ourselves as the citizens of Maharashtra and citizens of Tamil Nadu or citizens of Uttar Pradesh. Here anybody can go anywhere and reside anywhere and settle in any part. Okay, so I can go to Bihar. I will not obviously, but I can go to Bihar and settle over there, right? So this is allowed perfectly, and the freedom to practice any profession is also included. Okay. Of late, right to information has also been included as the right in the freedoms under the Article 19. Okay, so this sort of freedoms, they are very vital for democracy. If you don't have these freedoms, if you just remove those freedoms, as was done by Indira Gandhi during emergency, you would find that the democracy is not there. Okay, so there is no democracy. There is no meaning of democracy without these freedoms. So democratic participation of the people in the governance of the country would be vital. That is what was thought by the constitution makers, and hence they included the six freedoms when writing the constitution. Okay, so there, I suppose that these are the core things. If you want me to point out which are the defining things in the Constitution of India, I would say that this Article 19 is the most vital article as regards the civil liberties and as regards strengthening of the Indian democracy. Okay, because without this, you would not have newspapers writing against the government. Without this, you will not have people coming together and agitating against the government. Okay, without this, you will not have people migrating from place to place. Okay, in different areas, and they cannot practice any profession. So this is very vital. This Article 20, 21 and 22, they talk about the rights of accused also, okay, and personal liberty. Means, for example, you would find that if you watch some old Hindi movies, you'll find that there is an accused and that he is an accused and sent to jail, and he has been sent to jail because of some reason, which is because of some socio-economic reason is that, and that is the reason why he is an accused. Okay, he commits some crime, and because he or she is poor, he cannot afford the court cases. You know that it is very costly affair, litigation. But then, in that case, the government has to provide legal assistance free of cost. Okay. Then there is a right as to for how many days one can keep an accused in jail without actually filing a case against him or her. Okay, so all this are also considered to be vital, because otherwise it would be a police raj. If you don't have such kind of liberties, and even if you don't have the rights for the accused, because you know that many a times people are accused with a different intention, okay, with a political intention. So this right to liberty and right not to be taken into a custody, okay, and to be tried fairly in the courts, these rights are included in the articles 20, 21 and 22. Okay. Article 23 and 24 could be considered as the right against exploitation. Exploitation is defined in a limited sense. Limited sense means if you are employing a people without wages, okay, that is bonded labor, or if you are trafficking the people, means for example in prostitution, Veshya Vyavasaya, you'll find that girls are pushed into this prostitution because of this illegal business of human trafficking, or children are pushed into beggary kind of profession, begging profession, because of human trafficking. So there are some rackets who would take disadvantage of the poverty existing in India, and they would smuggle the human bodies, okay, and force them into some kind of labors which are not desirable. So such kind of human trafficking is made an offense punishable by law, and even employing people bandua, or it is called as bigari in Marathi. So this kind of labor is not allowed, and Article 23 clearly gives protection to the poor people, okay, who are forced to do labor without wages, and that is the Article 23. It's a very important article. It again, it's a negatively worded rights, but that is the rights of the poor people. So as I said, that fundamental rights would appear that the government is infringing on the right of the people to make money, but that's all right, because it is thought to be unethical for the people to force the poor people into the forced labor. Okay. Similarly, pushing the children below the age of 14 years in hazardous jobs like mines and cracker industry, all those things. So that was also considered to be a crime, and so the children are guaranteed this right against exploitation, okay, and this vital protection to the poor people and the children is also a fundamental right. Then I would come to a very important freedom. This is the freedom of religion, and that is included in Article 25 to 28. Often, this freedom would be interpreted as that the government is encouraging the people to practice and propagate any form of religion. That is not right. The right is basically to practice a particular religion, but not to forcibly convert the people to a different religion. Okay, so people have the right to convert, okay, to a different religion, but people do not have the right. The group of the people do not have the right to convert the people by force. Okay, by force, that is not allowed. So each community, each religious group has a right to preach their own religious fundamentals and propagate the religion of their choice. Okay, so this is allowed. That is, freedom of religion is allowed. Then people, you will find that there are some murds of religious gurus in India. That is because of this Article 26, because people can form own institutions, they can buy property, they can set up their ashrams, and they can have this audited under charity commissioner. All this thing is possible for a religious entity under Article 26. So that is the reason why you will find that there are various religious mutts and ashrams in India. That is because of Article 26. However, having said this, that 25 and 26 does allow the freedom to practice a religion, but still I would say that state is a secular religion. Our country is a secular country because it does not have a specific state religion. Like unlike in Pakistan, Pakistan would say that Islam is a state religion, but India do not have any state religion. In that sense, it is secular. In India, we cannot compel the people to pay taxes for promotion of any specific religion. That is Article 27. That way we are very secular. If somebody says that, if government says that, okay, you are supposed to pay taxes for construction of a masjid or construction of a mandir, I would say that that is illegal, because that violates my fundamental rights until Article 27. Okay. Also, if there is a government-run educational institute, we cannot, that educational institute cannot give religious instruction. Means, for example, if there are publicly funded schools, okay, publicly funded colleges, then those colleges or schools cannot impart a particular kind of religious education. Okay, so that is also prohibited. So if a group wants to promote religious education, they can establish their own schools and they can promote religious education. But if the government funds an education institute, then that religious instruction delivery is clearly prohibited. So that makes our country a secular country. So I just wanted to point out that Articles 27 and 28 clearly, and also the fact that we don't have a state religion, clearly point out to the direction that the country has adopted a secular constitution. Having said that, it does not mean that the people who are minorities like Jains, Buddhists, or Muslims or Sikhs, they might feel threatened that the majority culture would be imposed on them. Okay, so to clear that that fear from the minds of the minorities, like Sikhs, Muslims, Buddhists, Jains, okay, all these people, it was clearly written in Article 29 and Article 30 that state will promote the cultural and educational rights of the minorities. Okay, so Article 29 is about the state cannot impose culture on minorities, and Article 30 is that there could be some minority educational institutions, right? So people from Jain community, they can set up their own colleges and get a status of minority education institute. People from Sikh community can establish their own minority education institutes. Okay. Similarly, the people from the Islamic faith can also establish the minority education institute. So this is perfectly allowed in the Indian Constitution. So to sum up, and the last, as I said, was the right to seek constitutional remedies. Okay. So that is the last fundamental right. And as I said, because all these rights would be meaningless if you are not giving the right to constitutional remedies. So Article 32 and Article 226, we can approach the court and seek remedy if the fundamental rights are seen to be violated. Okay. So these are the six set of fundamental rights. That is the right to equality, right to freedom, right to equality under Articles 14 to 18, right to freedom under the Articles 19 to 22, right against exploitation, that is from Article 19 to 22, the right against exploitation under the Articles 23 and 24, right to freedom, the 6 freedoms which I talked about in Articles 19 to 22, and the cultural and educational rights which I just mentioned in the Articles 29 and 30, and finally the Article 32 and 226, they are the rights to seek constitutional remedy. Okay, that is, one can approach the court directly and say that his or her fundamental right is violated, and hence court should intervene. Okay, so all these things, if you want to summarize this, we would say that it does strengthen democracy. Okay, it strengthens the democracy because first thing is that especially the 6 freedoms which you talked about, they give the liberty to the individuals. Okay, liberty to the individual people. That would obviously strengthen democracy. Then it does give rights to the backward castes and communities. That is also important if you because we are talking about democracy in the right sense. We are talking about the democracy as the social democracy also. So the rights of backward castes and communities are given as a fundamental rights, and the rights of minorities. Okay, these are also important because India is not Pakistan. India is a secular, progressive country. Okay, so this rights of minorities is given, and obviously it is very impartial in terms of in matters of justice. Most of the people would have have to follow the rules and regulations. All of the people have to follow the same rules and regulations, and there is a single penal code, Indian penal code, wherein if you commit a crime, okay, the punishment would be the same, irrespective of whether you are from a specific caste or specific religion, okay, or whether you are rich or poor. So this is impartiality in matters of justice. So this, I suppose, this fundamental rights, they do strengthen democracy. Thank you very much.